Welcome to today's program titled Reopening New York City Co-ops and Condos, Guidance for Boards and Managing Agents. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Dennis Greenstein.
Thank you, Donna. Good morning, everyone, and welcome to the webinar. I'm Dennis Greenstein. I'll be moderating today, and we'll have several speakers. And I first wanted to share a COVID-19 experience with you. My wife and I have been working from our home in Berkshire since the end of March, and we received a call from Charleston, South Carolina about 5 weeks ago, along with an iPhone video about a very big and loving dog that needed a home, and we decided to rescue a 140-pound Swiss Mountain Dog and arranged to have him transported up to our house in the Berkshires. Down in Charleston, I should note, no one wears face masks because of COVID-19. So when the dog arrived, this enormous dog jumped out of the van, was very excited, he came running to us, and when he got to us and saw we're wearing face masks, he turned around and ran as fast as he could and tried to jump back into the van. I'm happy to say he's now with us, and we're all very happy, and whether we wear masks or not, he seems to be accepting his new home. Now, we all know that you guys could be spending this hour calling back all the residents of your buildings that are blaming you for everything that's making you angry, or them angry. So we thank you for joining us, and we hope you enjoyed the presentation. I'd like to just make a few observations before we get into the legal part. As you know, a firm represents a significant amount of co-ops and condo boards, and many of them ask the same questions, but not every building is the same, and neither is the answer. Many are big, many are small, some are retail space. Some buildings have lost revenues from retail tenants, some have majority of the residents over 65, some have no service elevators, some have many staff members, some have gyms and pools. And what comes up at times now is some boards want their gyms open now, some don't. And buildings do not allow residents to move out. Were rare, but it happened occasionally prior to this date. Simply put, not one size fits all, and the above situations need to be considered. We also need to consider what the governing documents of the particular co-op or condo provide. For example, allowing fines and legal fees for a breach. Some do not allow it, others do. So let's see what our speakers have to say during this next hour. We'll answer questions toward the end, and if any do not get answered during this webinar, please email them to us, and we'll get back to you by email or phone. In any event, I welcome all of you and hope you're all well and remain so. On today's agenda, we have three incredible speakers lined up, the first being Ingrid Manovitz. Ingrid counsels co-op and condo boards on all matters, and she also litigates many co-op and condo matters. We are incredibly pleased to announce, in case you missed it, that last week Ingrid was appointed to serve as co-chair of the New York State Bar Association Committee on Condos and Co-ops. Congratulations, Ingrid. This is well-deserved, and no doubt you will do an amazing job. I'd like to now turn it over to you, Ingrid.
Dennis, thank you for the introduction. Hello, everyone, and good morning. This is Ingrid Manovitz, and I will be speaking about issues and concerns for you to consider in connection with reopening amenity spaces in your buildings. New York Forward is New York State's four-phase reopening plan. The plan was announced by New York State Governor Andrew Cuomo on April 26th, and eligibility for reopening the state's 10 regions is being determined by public health factors, including each region's new COVID-19 infections, healthcare system, diagnostic testing, and contact tracing capacity. On June 8th, New York City entered Phase 1, and just yesterday, June 22nd, New York City entered Phase 2. Phase 1 included non-essential construction, limited retail, manufacturing, among a few other industries. As it concerns today's discussion, Phase 1 permitted co-ops and condos to resume apartment alterations and other building construction projects that had been put on hold due to the pandemic. Phase 1 also allowed residents and buildings to start new projects. Both resumed projects and new ones were, and continue to be, permitted subject to state-issued guidelines. Phase 2, which is the phase we are in now in New York City, includes real estate services, offices, in-store retail, hair salons, barbershops, along with a few other businesses and industries. Phase 2 allows in-person apartment showings and open houses to take place, subject to certain New York State guidelines. Phase 3 is expected to include restaurants and personal care establishments, and Phase 4 is anticipated to include recreation, entertainment, arts, and education. What do the current and next phases mean for the amenities in your buildings, like gyms, children's playrooms, and other indoor recreation spaces, such as movie theaters and basketball courts? There's still much discussion being had about these amenities, particularly gyms. What we do know now is that the governor's executive orders require businesses akin to some of these amenities to remain closed. These include commercial gyms, movie theaters, and both indoor and outdoor places of public amusement, which are specified to include children's play centers and bowling alleys. The two biggest questions regarding reopening amenities are when and how. As we continue to navigate this pandemic, the goal is to protect the health and safety of residents, staff, and visitors. While that has always been the goal when co-op and condo boards and their managing agents are making decisions, for obvious reasons, this pandemic has made this goal more acute. As Dennis mentioned in his opening remarks, one size does not fit all. Every building is unique, and as we tackle these issues together, we need to keep a few things at the forefront of our minds. We need to take each building's unique characteristics into account. We need to ensure compliance with all applicable laws and the governor's executive orders. And we need to closely monitor and carefully consider how to apply the guidance issued by public health authorities, including the Centers for Disease Control and Prevention, the New York State Department of Health, and the New York City Department of Health and Mental Hygiene. With all of that in mind, what are the next steps? The first step is to review your building's governing documents. For co-ops, those documents are the proprietary lease, bylaws, and house rules. And for condos, the declaration, bylaws, and rules and regulations. What do those documents currently say about your building amenities? And what should they say about your amenities in the world we live in right now? By way of example, for buildings with roof decks, your governing documents probably include rules relating to the roof deck. Do those rules address the health and safety issues posed by COVID-19? Do the current rules limit the number of people who can use the roof deck at a time so as to allow for social distancing? Do the rules encourage residents to wear face coverings while on the roof deck and to wash or sanitize their hands prior to using the roof deck? Different amenities present different challenges, and it's important to consider the challenges of the particular amenities in your building. Based on guidance issued by public health authorities, you may consider reopening outdoor amenities before indoor amenities. And as you drill down further, you may consider reopening the less popular amenities before the more popular ones to avoid crowding. Consider questions like, how may residents safely use the amenity, and will it be possible to monitor their use? As your board comes to decisions on reopening amenities, it is essential that those decisions be formulated into and adopted as new rules and regulations. Some buildings have been initiating policies rather than formally enacting house rules or rules and regulations in accordance with the requirements set forth in their governing documents. Policies are not the way to implement these changes. If challenged by a resident, policies are unlikely to stand up in court, which my partner Jeremy Cohen will explain in more detail later on in this morning's program.
Ingrid, if I can interrupt a second.
Of course.
Since many of the boards aren't meeting in person nowadays, how should boards go about, for example, adopting new rules and regulations?
Boards may meet over the telephone or virtually using programs like Zoom to discuss new rules and regulations. And then they should record their decisions to adopt new rules and regulations in meeting minutes. That way, there's a written record that the board discussed and agreed to implement the rules. Boards should also be mindful of when new rules and regulations become effective and how they should be communicated to the residents. For example, some governing documents provide that new rules take effect 10 days after copies are distributed to the residents, and that copies are to be placed under each apartment door. Boards and managing agents should strictly follow the procedures for adopting new rules and regulations set forth in the governing documents. Adapting your amenities to comply. You may need to adapt your building's amenities to comply with new rules and regulations. How will you reduce density and promote physical distance in your amenity spaces? Some buildings are rearranging furniture on roof decks and in courtyards and gym equipment in gyms to allow for social distance of at least 6 feet for when those amenities reopen. Others are removing furniture and equipment from gyms altogether as part of their reopening plans. Of course, if you remove furniture or gym equipment, you need somewhere safe to put it, and storage space is often scarce in buildings. Some buildings are considering having residents make reservations for amenities. Those buildings need to think about who will be keeping track of the reservations and making sure that residents only use the spaces during their reservation times. Other considerations include how to keep reopened amenities clean, when will building staff or an outside cleaning company be cleaning the spaces, and how regularly will those cleanings be. Building staff may need additional training regarding cleaning reopened spaces. Also, residents will need clear guidance as to how and when they should be using the spaces. In addition to distributing copies of new rules and regulations to residents, you may want to consider posting signs in the amenity spaces, reminding residents and staff of the new rules. Review your insurance coverage. You should consider reviewing your building's insurance coverage to see whether you have coverage in place for COVID-19 related claims.
Well, that's a good topic to ask another question, frankly. We're getting residents threatening to make claims against the co-ops or condos. And now I could see with these spaces opening up, do you think these claims would be covered by the insurance policies?
It depends. You would need to check the general liability policy to see whether it contains a virus and bacteria exclusion. If the policy has a virus and bacteria exclusion, I would expect coverage to be denied. If, on the other hand, there is no virus and bacteria exclusion in the general liability policy, there should be coverage. And as for D&O policies, it's unlikely that these types of claims would be covered, as D&O policies typically exclude bodily injury. As you prepare your budgets for the coming year, be mindful of the costs you may incur for cleaning products and materials, PPE for staff, and new signage in amenity spaces. Also consider increasing your budget for legal expenses, as you may need to consult with counsel more regularly regarding the adoption of new rules and regulations and residents who do not comply with them. Continue to closely monitor the guidance. New guidance is being issued frequently, and it's important to keep up. We recommend that you closely monitor the various websites where guidance is posted by New York State, New York City, and the Centers for Disease Control and Prevention. In addition, REBNY, the Real Estate Board of New York, has issued guidance specifically geared to market rate residential buildings, which you may find helpful. Accommodations for vulnerable populations. Depending upon your building's population, you may want to consider setting aside particular hours during which residents who are 60 years of age or older may have exclusive use of amenity spaces. My partner, Paul Galligan, who's up next, will be addressing accommodations during his presentation, so I'm going to stop here. Thank you, everyone.
Let me introduce Paul to you. Paul advises and litigates employee and employee-related issues and is a partner in our Labor Employment Department. Paul advises on all aspects of discrimination law, as well as 32BJ service employees' international union issues, which often involves co-op and condo buildings. He has been very active in our COVID-19 staff issues that have surfaced in many of our buildings. I now turn this over to Paul.
Thank you, Dennis. It's funny because I have a little story, a little shorter than Dennis's story, which is my brother, who lives in Dublin, texted me at the start of this whole COVID pandemic and said, "Are you ready for this ride?" And the question, I guess I have the same question for you, because it seems as if this is like the roller coaster ride that never ends. So, and I think that will populate a lot of the issues that I have to discuss. Is this ride ever going to end? And it just keeps going up and down. And there are a lot of questions and not many answers. So I appreciate your time today. I'm going to move to my first slide. So one of the advantages that you have as people running co-ops and condos, managing them, being employed in them, dealing with residents in them, is is that you've been dealing with employee safety issues for 3 months, whereas a lot of businesses are now just reopening and having to deal for the first time with a lot of these issues. So I think that's an advantage, even if you've had to change your position on certain things. But so I think the first question really is, what have we learned as an essential service? What have you learned as an essential service? So over the last 3 months, employees, building service employees have been coming to work and sharing space with residents who are living in that space, and it's an indoor space for the most part. Employees and residents are used to safety protocols being in place, and I think that we've learned that there's a need for consistency in how we operate, how we deal with these safety issues for both employees and residents, but also the need for compassion, because you're dealing with such a serious and tragic issue, and everybody's afraid, everybody's concerned, and nobody, the guidance keeps changing. So having to deal with all that, at least you've been dealing with it for the last 3 months or so. So conducting building service work, if you're a union represented building, you employ building service workers. Building service is, defined in the collective bargaining agreement, which you either have through the Realty Advisory Board or an independent agreement, but it's never really been defined. I've been working in this industry on both sides of the ledger for 30 years, and I've never seen a definition. And that's to be to your advantage, because building service work essentially is what the workers do, and they work in common areas and they work inside resident apartments, and so you have a lot of leeway in what you can require building service workers to do. But it's complicated in the COVID-19 environment, because you've got to address safety issues. You have legal responsibilities to provide a safe place to work, and so you have to be understanding and have a closer look at what employees are doing in the buildings, particularly inside the apartments, where employees would typically work. But, nobody wants employees to be in residents' apartments. The residents don't want them. The employees don't want to be there. And so you have to be very careful about how you how you deal with that work. Are you only dealing with emergency work? And that's a question that has to be posed and answered by management, so that the employees and the residents can be advised of what work is going to be done, what steps are going to be taken. Now, union buildings, you've got union buildings, non-union buildings. I'll deal with union buildings first, although there's very little difference between how you operate in both under COVID-19. Union buildings, you've got obviously the union, typically Local 32BJ. I would say that, in my experience, Local 32BJ has been very cooperative and understanding in addressing these issues. Do you have a duty to bargain over safety precautions? It's a gray area. It really depends on the collective bargaining agreement, but in this case, given the emergency that we're dealing with, the best practice is to keep the union informed of what you're doing, discuss it with them if requested. If you're covered by the Realty Advisory Board agreement, you have additional agreements that the Realty Advisory Board has reached with the union. There was one in March, right after the pandemic hit and the lockdown ensued, and then a more detailed one which was issued at the end of May. You should review both of those, as a lot of work has gone into that from both sides. A lot of it deals with commercial buildings, and they're in a completely different situation. But there is some guidance for residential buildings.
Paul, this is Dennis.
So, yes, sure.
Sorry for interrupting, but I'm going to keep doing it.
Mm-hmm.
We
That's
have
okay.
a lot of repetitive questions that come up from many of our boards, and as you're speaking here, we've got, I think, one big issue comes up with that we have boards that want to give the name of the staff member that has COVID-19 virus, and I understand the logic. The logic is that they want to know if they're around that person. Did they have exposure to that person? And and I think we all have heard over and over again, if people on the phone haven't heard it, that it's a protected class. It's considered a disability, and secrecy about the individuals doesn't seem to be challenged as much. But when it comes to staff, I find a different reaction from the boards. And I get it, because they're getting pressure on themselves from the shareholders, and it just logically seems to be the right thing. Is there guidance on this from the Real Estate Advisory Board and the union, or is this just the general rules that apply to anybody with an illness? And what should be told about the response to that question? That yes, we can't tell you the name of the staff member.
Yeah, Dennis, I'm going to deal with that in detail later. I'm going to simply answer your question that It's not dealt with in either of the ORB agreements, except that they do refer to compliance with all applicable laws. And there is one applicable law that governs this, and that's the New York City Commission of Human Rights has declared that a person who has the COVID virus is a disabled person, and that person could also be perceived as disabled as well. So that presents a whole set of obligations, which I'll discuss later. But essentially, to answer your question, because the employee, and then we're dealing with the employee here, or I guess your question covers residents as well. What's come up several times, in fact, probably several hundred times, is the employee or the resident has informed the board or the managing agent that they've tested positive or they have the symptoms of the virus. And I think that the basic duty is that you have a duty and obligation to inform the coworkers who have worked with the employee, and also the other residents in the building who share the building with the resident who has the virus. You cannot, under any fair reading of the New York City law, you cannot identify that person, whether it's the resident or the employee, because you're infringing on their rights as a disabled person. You're identifying their disability. And also, I think there's, even though you've said there's a desire to the questions that are going to be asked by residents and other workers, like who is it? We need to know because I need to find out how close I was to that person. They're legitimate questions, but they are overridden by the law. If you disclose the identity, you're violating the New York City law, potentially the federal law as well, which hasn't come out and said that it's a disability under federal law, but it doesn't matter because we're all living and working in New York City. So you cannot identify the person because of their disability, but also you're subjecting yourself and the building to litigation over the matter. If you identify the resident or the employee, you are, then the employee or the resident gets ostracized or bullied or treated differently by coworkers or residents. You're opening yourself up to a lawsuit on that basis. So I think the best practice is not to identify. And I'll address this a little more in a minute.
Thanks,
did I answer your question, Dennis?
Yep, sure did.
For the most part. Okay. All right. So I'll just move on. There are several agreements, and I won't go into them. Some of them are fairly lengthy from the Realty Advisory Board with the union. About a lot of them deal with pay issues. There's pay. Employee is sick and the employer directs them home based on a workplace transmission, and who knows when that happens. But employee may be entitled to 14 days pay in addition to any paid time off that they have. You may be familiar with that. There's also pay issues under the federal law, the Families First law. Under certain circumstances, employees who have COVID or family members of COVID are entitled to paid sick leave or paid family medical leave. I could spend 2 hours talking about that for once, because a lot of these laws are written on the back of napkins in response to the disaster. So there's also the city, the governor issued emergency leave pay, and that's also got several conditions. But these are all issues that need to be dealt with if you have an employee who's sick. So that's one thing. Typically, a local 32BJ has been cooperative, as I said, but I also think that there's a duty to inform the union rep if you're changing conditions or dealing with a particular issue in the building that impacts employee safety, just to notify them so you don't have any trouble, and also employees then can have their concerns alleviated by the union. In non-union buildings, non-union buildings like union buildings have the same obligation to have a safe workplace. So you're dealing with the same safety issues. You just don't have to negotiate with the union over them. You may be dealing with what's called protected concerted activity, which is typically two employees or more who come to you as the employer, the manager, with safety concerns. They are protected from retaliation for raising those issues. It could even be one person who's raising the issue on behalf of himself or herself and others. That's one to watch, because you typically don't look at that in non-union buildings as being an issue. It's also applies to union buildings. You can have concerted activity in union buildings as well, but typically that's dealt with through the union. You may have requests for hazard pay or bonuses, and from employees that would also be concerted activity typically. So you just need to address it. You don't have to give in. You don't have to accede to the requests, but you have to address them, and you have to not retaliate against employees who raise them. Duty to accommodate. We kind of touched on that in my answer to Dennis's question. You have a duty to accommodate employees who have the virus, who've been exposed to the virus. What does duty to accommodate mean? Essentially, the main part of it is you have to meet with them or talk to them and explore alternatives, accommodations, reasonable accommodations. And you have to determine whether the accommodation that's been requested or proposed would cause an undue hardship to the building. these are the main thing is to have that discussion, and I can't emphasize that more, and I'll be addressing it in a few minutes as well. To have the discussion, to try and work out, try and address the concerns, between the worker and co-workers, scheduling, things like that. Moving on to new labor issues with the New York City reopening, as Ingrid said, it was a phased reopening in New York City. You've been, like I said, dealing with these issues for 3 months, safety issues for 3 months or more with the employees, and now you've got additional safety issues. You have mass transit. That's a big one. This week, New York City entered phase 2, so you're going to have a lot more people on mass transit. It's going to be very difficult to maintain safety on mass transit. Let's not kid ourselves. And this puts pressure on building service employees coming to work on mass transit, obviously. And so you're going to get concerns raised by employees about coming to work. And you're probably best advised to try and accommodate those requests, even though it may not be someone with a disability as such. You should address concerns on a case-by-case basis, but also with a view to consistency of response. Because workers coming to work on mass transit and residents using mass transit does create, potentially increased exposure for people in the building. So it has to be dealt with. I'm not sure, again, this is one of those things where there's many questions and absolutely no answers. You can urge employees to practice safety protocols, particularly on mass transit, wearing masks, et cetera, following the guidelines of the mass transit that you're taking, particularly usually a subway in this case. With regard to testing, you've got buildings are going to differ on how they monitor employees' health going forward. So we can't really address all the issues there. I think consistency is important. Whatever mechanisms you put in place, just make sure it's consistent and legal, obviously. Asking employees to self-test presents an issue. I don't see a problem with it as such, but I think that there's a question about whether that's reliable. There's also a question of cost. Who pays for the test, and who pays, more importantly, for the time? If you're requiring employees to get tested, to wear equipment, then you're best advised to pay them for that time. It's part of work time. You could argue back and forth on that, but that's my advice. There's also a question of confidentiality that's raised with the tests that I also addressed earlier. Keeping these issues confidential is important. The next issue that you may deal with, and maybe you've already dealt with it, and I'd appreciate the feedback on that, because there's another one with no answers. Refusing to come to work. Employees who are particularly high risk, elderly employees, may refuse to come to work, particularly with the mass transit issue. How do you deal with that? Legally, the question of whether you have a duty to accommodate such a person is not resolved yet, as I said. But I think we would recommend have a discussion with the employee, seek to find a solution. Obviously, with building service employees, you really don't have the opportunity to have the employee work from home. So that solution is out, but there may be other solutions, and the only way to get there is to talk about them. If you require high risk or elderly people to come to work, you're creating morale issues potentially with residents, particularly with long-term workers who have developed relationships with residents and now being forced to come to work even though they're afraid or high risk. So that's a complicated issue. You could explore issues of paid time off, unpaid leave of absence, moving shifts. One of the Realty Advisory Board agreements, at least one, I think more than one, emphasize the fact that you have the right to change shifts to deal with these issues. So you could put somebody on a less travel shift, overnight shift, 12-hour shift, minimize the mass transit or the fear issue of coming to work. Again, this all needs to be discussed with the employee and potentially with the union rep if the union rep wants to be involved. Another gem is off-duty conduct. Frankly, I wouldn't touch this one. It's a very tricky subject, but in this case, there is a concern. What are employees doing? How are they practicing safety on their own time? Are they going to raves or rallies without masks? And that potentially presents an issue of exposure when the employee comes to work, especially in an apartment building with the residents, etc. And you may even get pressure from residents to create rules addressing off-duty conduct. Be very careful on this one. But I think it's best at this point to urge safety outside work, conduct training, and if you have to, you have the opportunity to do contact tracing, which is kind of shutting the barn door after the horse is bolted. That's my first and last cliche on this program. There's the last part of the slide concerns the duty of building service employees to conduct safety protocols for residents and guests. Yeah, so you've got another advantage here for being an essential service is you've been dealing with these issues, but now you've got more visitors, or you've got visitors now coming into the building, contractors, more residents coming back from the Berkshires. And so you've potentially additional duties for the employees, and you may have some flack over that. You have to address those concerns from the employees. I've seen issues where employees are asked to conduct temperature tests. I think, frankly, that's difficult to do. I mean, employees in building service industry tend to do what they're asked to do because they're a service group, and they're generally very cooperative, but if possible, take a lot of that load off them. They're going to have other obligations to do, but conducting testing, having visitors sign waivers and disclaimers, it could be difficult for the doorman to do that as they're doing all the other things that they have to do. So just consider that and the requirements that you're using. Moving on to privacy and confidentiality concerns. I'll be quick on this one because I've already dealt with it somewhat. You've got, New York City is treating, as I said, treating employees who have COVID-19 as disabled. So you have a notification requirement typically to inform coworkers and residents of a positive test, but not who has tested positive. One question that I didn't answer earlier, board involvement. Dennis and I have come up with this several times. The board wants to be involved in dealing with this issue. We think, given the potential litigation that could ensue from all of this stuff, that board involvement should be kept to a minimum, because you should let it, if you have a managing agent to handle it, I think that's advised as one point of contact, consistency, and also it takes the board members out of the pressure from residents to identify people because they're out of the loop. So that's our recommendation, and I think it makes it simpler and more professional to do it that way.
Paul, Dennis,
yes.
On the issue with the board involvement, is it better or not better to have the board go through with the managing agent in terms of giving their input about how they feel the staff should be treated, yes, in terms of any resistance that may come? Like, I'm not going to go into an apartment, I'm not going to deliver food. And I know you emphasized, and that under the city law you have to have cooperative dialogue with anybody who is disabled. Is that as strong an issue with the staff members as it is with individual residents? And again, should the board just be turning it over to management? And and dealing with the questions to insulate themselves from being accused of selective enforcement against any staff member.
Yeah, I mean, these are the issues that we've dealt with, Dennis, and I think that residents and employees, to me, are in the same boat here. And I think that protecting the identity of both is probably the most important thing, given the threat of future litigation. But also, the boards can obviously direct and the managing agent who works for them on how they feel and how they should proceed, but it's the managing agent who needs to take the action and be the face on this, so that they deal with the the residents' pressure, which I think is the biggest concern. Residents pressurizing individual board members to provide information, and I think it's easier for the board member to say it's not something that I'm privy to, and that makes it easier, and also hopefully insulates board members and the board itself from litigation. Depending on how this goes in the future, with what I said earlier about having identified an employee. And look, we all know that, that usually people know who it is, whether it's a resident or an employee or even a resident superintendent, where, obviously we dealt with that issue as well. They know who it is, but that doesn't mean that you identify them, because they have rights. So that's where I hope I answered your question, Dennis.
Yes,
I'm just going to move quickly on to record keeping. I can be very quick on this. Keep records. We don't know yet how long you have to keep records. The records, and I'm talking about obviously, are any testing that's been done, any temperature data that's been taken, any individualized assessment. Document your efforts to accommodate people, residents, or employees. OSHA basically requires it. They require you to log recordable illnesses. So you can take that and add and just keep records of everything for obvious reasons. But we get a lot of questions how long keep the records. That we don't know yet. But for now, just keep them confidential as well. Like you would any disability dialogue that you have with employee. And finally, this third section, which I'm also handling, which is addressing New York human rights law and accommodation requests, is actually the New York City human rights law that's in question. Recently, as I alluded to earlier, the New York City Commission issued a proclamation or an order that a person with COVID-19 is disabled. And part of that order states, in quotes here, discrimination and harassment due to COVID-19 are illegal in New York City. So there you have it. And you all know that cases of discrimination and harassment could come up based on far less than this. So the first question, as I said earlier, the first obligation is to consider the accommodation. Under the New York City law, cooperative dialogue, which is what they call it, is mandatory. And this applies again, I couldn't stress more, where it's a person is disabled. So a person, it could be an employee, it could be a resident, could even be a visitor. The cooperative dialogue in that case is mandatory, and that means that somebody, again, we recommend that it be a point person with experience, who can engage in the cooperative dialogue with the resident or the employee to work through the issues. What is the issue again? That person is going to be privy to some sensitive information, but that's unavoidable. And sit down and work out for the resident. What are their requests? Is it reasonable? Does it create an undue hardship? If you give in to this request, what other requests are you going to deal with? How does this impact the other residents, et cetera, et cetera? All of this is part of the consideration process, and it basically is the dialogue with the resident or the employee working through these issues and trying to find a solution. You have to do it. You have to document it. Again, you don't reveal the identity. We advise that. And, the New York City human rights law goes further. As I mentioned earlier, it's not just an actual victim of the virus. It could be a perceived victim of the virus. If a resident or employee is perceived to be somebody who has the virus, then they are also considered disabled. So that's one to watch for. Dennis or Jeremy or anyone can deal with have more experience dealing with how you deal with residents. You've got eviction issues, you've got extra charges. All of this could potentially impact the New York City human rights law. And I'm going to turn it over to Jeremy, who's going to take us home.
I'll just do a brief introduction. Thanks very much, Paul. And just a quick note, if as a managing agent or as a board member you get any threats by someone, we're going to sue you for this, make sure you alert your insurance companies and your insurance broker that there may have been there's a potential claim. We don't want anybody shut out later on if they should bring a claim saying that you knew about this and it's a delayed notice. Our last speaker is partner Jeremy Cohn. Jeremy is in our litigation group and he handles all manner of business and real estate litigation, including anything relating to coasts and condos. And Jeremy is twice been recognized as one of the top 100 lawyers in the New York metro area of all practice areas by the Super Lawyers magazine. So, Jeremy, you're on.
Thanks, Dennis. That nice introduction almost makes me feel bad for wondering how quickly your dog would have run away if you didn't have the mask on. Before I dive in, for those of you who are here to get some CLE credit, and at the risk of losing you as the audience, I am going to give you the CLE code right now. The code is SS, as in Seyfarth Shaw, 2623. Again, SS, Seyfarth Shaw, 2623. I'm going to focus my comments on three broad areas that relate to litigation. First is the lessons we've learned over the last several months of COVID-19. Then I'm going to talk about the current state of play in the courts, and then with a tip of the cap to the rock band, the Eagles, we're going to look at what is somewhere out on the horizon as far as litigation issues go. So in terms of lessons learned, board decisions, even in the non-COVID world, are typically protected in New York by the business judgment rule. It's an expansive protection that basically says if building policies are adopted in good faith and without self-interest, they're going to be enforceable. They'll pass muster if and when challenged. In terms of COVID-19 policies that are geared towards protecting health and safety, almost any policy will pass muster under the business judgment rule. It's hard to envision a health and safety policy that wouldn't pass business judgment rule review. And that's especially so when you've got government orders, you've got the executive orders from New York, you've got some real estate industry guidelines that are all in harmony with the types of health and safety measures that buildings are adopting. But the business judgment rule is not limitless. Emergency policies, even reasonable ones that conflict with a co-op proprietary lease or condo bylaws, are not going to be enforceable and might even create some exposure for the board. But that sort of legal principle runs up against some practical realities at a time like this, when courts are not as open or haven't been as open as they otherwise would be. When boards have adopted policies that contravene the proprietary lease or bylaws, in many cases, nothing has happened. And there's a lot of reasons why that might be. One is that residents don't have the time or the inclination to fight over some of the issues that are presented by these policies. It's hard to get into court right away right now, and it's getting easier, but over the last few months, in order to get into court in New York, you had to have what's considered an essential or emergency matter, and that's a pretty strict requirement. Although we haven't seen it in New York, in courts elsewhere, there's been some very strident decisions by courts where parties have tried to get in claiming emergencies. In fact, there was no emergency, and there's been sanctions and things like that. So while the fact is a shareholder could complain if a COVID-19 policy conflicted with the proprietary lease or bylaws, by the time that anyone was able to get into court, either the issue is passed, or in many cases, buildings initially adopted strict policies and then kind of lessened them as the numbers seemed to go down around the city as we moved into new phases. But that said, there's been at least one case decided, and it was decided in May, that at least implicitly held that the COVID-19 policy, in this case a smoking policy, was unenforceable. There was a building that adopted a building-wide no smoking policy, even in individual apartments, and the reason for that was because so many people were now under stay-at-home orders, and of course COVID-19 being primarily a respiratory illness, the building wanted to impose what it viewed as a prudential safety measure, health and safety measure. The problem was there was nothing in the lease that allowed for a restriction on smoking. There was a neighbor of a woman who was smoking in her apartment who was complaining about smoke permeating into her apartment, and it ended up in court. And what the court did was it basically ignored the COVID-19 policy, treated it as if it was never enacted, and just considered the matter on its own accord under the same types of rules it would have used in a non-COVID-19 environment. It considered whether the building and the neighbor had provided evidence of smoke permeation, and found that there wasn't enough evidence in order to issue an order directing the woman not to smoke in her apartment, notwithstanding that the building had adopted a policy during COVID for not smoking in her apartment. So,
wow, so New York courts, Jeremy, and everyone thinks they're notoriously pro-tenant. Is this an example of that?
You know, it's first of all, I agree. I think everyone who's listening and knows these issues would agree that New York courts are notoriously pro-tenant. They bend over backwards. I'm not sure. This case may just be an example of the court feeling that the evidence just wasn't there, but it's certainly possible that even in the COVID environment, the pro-tenant, call it bias of the New York courts is at play. But on the other hand, there's at least one other case that's come up in the past month or so where a court did enforce a COVID-19 policy. It was a building that restricted the number or actually restricted outside guests altogether from going into apartments. And there was a shareholder and his roommate who were hosting parties and making a lot of noise. And in that case, the court issued an injunction that said the guy couldn't have any more guests in his apartment unless there was a medical need at some point. And not only that, but as a procedural matter, set the case down for further proceedings at the end of July, which, and the order was issued in May. So it's almost a pocket veto on the issue. It said for, at least for 3 more months, I'm not even going to hear any more from you on this. So, I think at least anecdotally, the sense is that courts are trying to do what's right for the most number of people within the confines of the law, and maybe the pro-tenant bias is somewhat tempered by COVID-19, especially where a tenant is doing things that create additional exposure for people. And you can see the difference. The smoking case, there was nothing about it that created an additional COVID-19 exposure, whereas having guests come up to the apartments might. So, and going quickly down the rest of the list of points on this slide, there's some other issues that have come up, and they're kind of tricky. Caretakers for people who might be disabled or elderly. The human rights law requires reasonable accommodation. So if someone is disabled and needs a caretaker, you can't very well say they can't come in. But what you can do, and we've enlisted our ADA team at Seyfarth to work with our clients to develop reasonable approach here. The key word is reasonable accommodation. And so we've come up with plans that involve testing for the caretakers prior to coming into the building, the use of PPE and protocols for how PPE will be used and where in the building the caretakers can go and that sort of thing. It can be a little trickier with some of these issues. Babysitters, we're at one point not considered essential, and a lot of buildings were not letting babysitters in. But then that begged the question, well, what if someone is an essential employee but can't go to work if the babysitter couldn't come to the apartment? And I haven't seen litigation on that issue, but it's one that we were dealing with a lot of our clients and trying to formulate plans that were similar to the caretaker plans in many cases. Moving in, moving out restrictions are also tricky. You can't hold someone hostage by saying they can't move, especially if it means they're going to end up paying rent in two places. There might be accommodations that have to be made in terms of either deferring or eliminating rent or maintenance, that kind of thing. These issues haven't been litigated that we've seen, at least not yet, which isn't to say they won't be when the courts are back to a more normal mode of operation, which is a good segue to the courts are slowly returning to normal. So the New York courts are back open. They're still doing a lot virtually. They are still operating very slowly. If New York courts are notorious for being pro-tenant, I think they're equally notorious for being very slow. Not necessarily their fault. There's huge backlogs, and by closing in effect for 2 months, that backlog has only gotten worse. So things are moving slowly. I think probably everyone on the call knows there's been an eviction moratorium, which at least in theory ended as of June 20th, but extended till August 20th if people could demonstrate a COVID-related hardship. It's a pretty low bar. So in effect, that extended the moratorium for everybody till August 20th. And in addition, that was pursuant to the governor's order. The courts themselves have stayed all eviction cases until July. So not a lot of action there. But if evictions aren't allowed, that doesn't mean that you can't file claims for unpaid rent where you're just seeking to get an order that the money is due. You can issue defaults based on unpaid rent. You can pursue claims for arrears as long as you're not also pursuing an eviction. And also in the context of co-op condo matters, already since the courts have reopened, we've seen cases involving 881, where you're looking for a license to enter onto a neighboring property to do your local law 11 work. We've seen cases involving access within apartments where you need to open up someone's wall in order to access building systems. We've seen nuisance cases. There is at least one other smoking case where a court did issue an injunction to prevent someone from allowing smoke to permeate common areas, but that's nothing COVID specific. That is just a typical kind of smoking case. And so there's going to be typical odor, noise, smoking cases, and everyone's favorite torts where someone slipped and fell on the sidewalk outside the building. Those are also now going. So the categories of cases that I've mentioned already is really what we see coming on the horizon, with the one exception being that at some point evictions will be available again as a remedy. But in the meantime, accumulated arrears, fines. Many buildings have implemented policies related to COVID that include fines for noncompliance. And so there could be claims about whether those fines are authorized by proprietary lease or bylaws. There could be people claiming they couldn't move and sustain damages because either they were paying for rent in two places or other related damages. Many buildings stopped real estate showings. So people who listed their apartments and couldn't sell might try to bring cases, although I think those will be difficult, in part because it'll be hard to prove damages given what the market was doing throughout COVID. Proving that you would have been able to make a sale could be tough. But as all of these issues are sorted out in the courts, I think boards can continue to find some cover in the government orders that have been issued. If you were trying to comply with the government orders, even to a lesser extent, industry guidelines, revenue guidelines will provide some cover. They don't have the same force of a government mandate, but at least tend to show what reasonable practices are in the industry. So these are some of the issues that I think we'll see. And it brings me to what I think is a key looking forward point. It's not a litigation issue per se, but to the extent that we're seeing litigation possibilities, it relates to things like whether the board had the authority to prevent a move-in, move-out, to impose additional conditions, to set up a regime involving fines for noncompliance with COVID-19 protocols. Right now is a good time to consider amending proprietary leases or bylaws in order to ensure the primacy of emergency policies in the event that either this pandemic doesn't go away very quickly, as it seems like it may not, or for the next one, so that there's no question as to the board's authority to enact policies and that those policies would be consistent with your governing documents. I think Ingrid mentioned insurance. It's also a good time to review your insurance coverage to make sure you've got the appropriate protections in there. Those are some forward-looking things that are not necessarily litigation issues, but I think are worth boards thinking about and consulting with counsel about. The final thing I would mention, if you don't amend your documents, how do you enforce the rules that you've implemented in the meantime? And kind of looming out there, even if a particular policy is inconsistent with the proprietary lease, there's always the hammer of objectionable conduct. We haven't seen any case like this yet, but if someone's flouting all of the protection, walking around, coughing on people and doing things that seem either intentional or just completely reckless without regard for everyone else in the building, and particularly if they continue to do it after being advised not to, the hammer of an objectionable conduct termination of a lease is always looming out there as the sort of the big arrow in the quiver. And with that, I'm going to turn it back to Dennis to wrap things up. I know we have a couple of questions maybe, but also people should feel free if you have any questions to type them in. We'll hang out for another couple of minutes, I suppose.
Can we go to the next slide to just give them the contact information? Anybody who wants, we've actually answered a couple of questions. We have another one here, number 7, Paul, if you could take that. But just to let you know, we're going to keep this open for a little bit so we could finish a couple of questions that we didn't answer. But feel free to email any of us. We'll either call you back or email you back. And also, we understand the fear, the anxiety, the reality of the situation, the pragmatism, and to be empathic at the same time as being compliant as board members, managing agents, to try to protect everybody against claims when all else feels like it's falling apart. We hope you're all well, and thank you for joining us. And again, we're going to keep this line open for a little bit to try to get, I think we just missed a couple of questions. If we don't get to everybody again, send it to any of us at our email address. And Paul, if you could take what we're going to call question 7, that would be terrific.
Sure. Thanks, Dennis. Very quickly, there's a question about whether we should maintain records of temperature readings, and there are several places where it's said that we should not maintain those records. I think it really depends on what temperature taking is being conducted. If you're having employees take their own temperatures before they come to work and then report in those temperatures, I think a document should be made of that and kept, if only to ensure consistency and be able to demonstrate it, particularly if there's an inquiry, either particularly from OSHA with regard to maintaining a safe place to work. I mean, if you're just doing temperature readings where you're zapping somebody's head with one of those machines they now have, that's happened to me a few times already. I can't remember what they're called. You're not really in a position to maintain those records because you're just checking the temperature as they come in the door. And I don't really see the need to do it in that case. But again, this is all about being able to demonstrate first of all, for safety reasons. You don't want people with high temperatures in the workplace or in the residence, and but it's also a question of being able to show that you took all necessary safety precautions. And if this is one that you've put in place, then I don't see any harm in maintaining records to the extent you can. Thank you.
I don't know if we have any other questions we haven't answered. Are any on any of your screens, guys? Nope. Okay, so thank you all again.
Dennis, sorry, one thing I forgot to mention that is I said it earlier. Sure. The question, actually this question is a follow-up question on the same topic. Are we required to take temperature? Absolutely not. In fact, I think that temperature testing is only one part of it. You can have the virus without having temperature. So I'm not sure how much that is worth, and I think it's just more a question of self-protection at this point. But also, any of those records should be kept confidential. I just want to emphasize that. Thank you.
Okay, great. All right, thank you everybody for attending. Again, be well, be safe. We're around if you need us. You know where to reach us. Everyone have a great day.